On March 27, 2018, a jury found James D. Worley guilty of 2 counts of aggravated murder and the specifications attached thereto. The state elected to proceed at the sentencing phase with specification 1 attached to count 12 of the indictment. That specification provided the defendant committed the offense for the purpose of escaping detection, apprehension, trial, or punishment for another offense committed by the defendant. The capital murder charge arose as a result of the kidnapping and subsequent murder of Sierah Joughin by the defendant. After the verdict in the trial phase was announced, the defendant declined the option of a pre-sentence investigation and/or a mental health evaluation. The defendant was fully advised of all of his rights before the court proceeded to the sentencing phase. The sentencing phase was scheduled to commence on April 2, 2018. At that time, the court was informed by the defense that they had only received the report of its mitigation specialist, Dr. Fabian, the day before, and had not had time to review that report with the defendant. As a result, the defendant requested a continuance of the hearing until April 3rd of 2018. Testimony on the sentencing phase commenced on April 3, 2018. The court permitted the state to use only selected trial exhibits during the sentencing phase. The defendant raised no objection to the testimony and exhibits which the state wished to utilize in the sentencing phase. The defense presented 5 witnesses in mitigation. The defense also presented a tape of the defendant's sister, which had been obtained by the defense investigator, Mr. Gary Erickson. The defendant's presentation consumed the entire day. On April 4th, 2018, the defense rested after admitting its exhibits. The jury heard final arguments from both the state and the defense, and the court then instructed the jury. After approximately 6 hours of deliberation, the jury returned a sentencing verdict finding the state of Ohio had proved the aggravating circumstance outweighed the mitigating factors beyond a reasonable doubt, and that the penalty of death should be imposed in this case. During both the trial phase and the sentencing phase deliberations, the jury was appropriately sequestered. During the trial phase deliberations, the jury was sequestered overnight. The jury's verdict of death constitutes a recommendation to the court. The court is required to perform an independent review of this matter pursuant to Ohio law. Based on the sentencing verdict of the jury, the court must now weigh the specific aggravating circumstance involving the aggravated murder of Sierah Joughin and the mitigating factors to determine whether the jury's recommendation of death as to that aggravated murder charge should be the final sentence of this court. Defendant James D. Worley was found guilty beyond a reasonable doubt of purposely causing the death of Sierah Joughin while committing or attempting to commit, or while fleeing immediately after committing or attempting to commit the offense of kidnapping. In addition, the jury determined beyond a reasonable doubt the defendant committed the aggravated murder for the purpose of escaping detection, apprehension, trial, or punishment for another offense committed by the defendant. When the death penalty recommendation is made, the trial judge must then deliberate and render the final sentence. Guidance is provided by case law and pursuant to the requirements of Chapter 2929 of the Ohio Revised Code. Ohio law requires the court set forth its specific findings as to the existence of any mitigating factors pursuant to Ohio Revised Code Section 2929.04b, as well as any other mitigating factors, the aggravating circumstances a defendant was found guilty of committing, and the rationale for the court's reasoning behind the weighing process. In determining this matter, the court has considered and weighed all the appropriate matters required by law. This court has considered the aggravating circumstances found by the jury beyond a reasonable doubt involving the aggravated murder of Sierah Joughin and the mitigating factors as disclosed both during the trial phase and the sentencing phase. I'm now going to provide a factual background and findings by the court as to the specific aggravating circumstance. The aggravated murder was committed for the purpose of escaping detection, apprehension, trial, or punishment for another offense committed by the defendant. On July 29th of 2016, Sierah Joughin was a 20-year-old college student living with her grandmother in rural Fulton County, Ohio. On that date, Sierah decided to ride her bicycle to her boyfriend Josh Kolazinski's house. After a brief visit, Joshua and Sierah rode together. Sierah was on her bicycle, Joshua on his motorcycle. After riding together for a short period of time, Joshua returned home and Sierah continued on her bicycle ride. That was the last time she was seen alive. Later that evening, Mr. Kolazinski tried to reach Sierah. He called Sierah's grandmother and mother, and it was at this time that the family members became concerned about Sierah's welfare. The Fulton County Sheriff's Office was contacted. An extensive search for Ms. Joughin was undertaken not only by law enforcement but also by the public. Later on County Road 6 in Fulton County, Sierah's bicycle was found in a cornfield. Her sunglasses were found on the road. Across the road, investigators discovered the crime scene. At the crime scene, investigators found blood-stained corn leaves. Later testing revealed the blood was a DNA match for Sierah Joughin. Investigators also found a box of fuses, a screwdriver, and sunglasses, all belonging to the defendant. Tire tracks located in the field were later matched to the defendant's Dodge pickup. A passerby found a motorcycle helmet off the roadway adjacent to the crime scene. The motorcycle helmet was later revealed to have bloodstains on the exterior. The bloodstain matched the DNA of Ms. Joughin. The defendant's DNA was also found on the helmet. Investigators met with the defendant at his home. After a discussion with the defendant, investigators obtained a search warrant for the house, surrounding property, and outbuildings. In the northern portion of the barn located in the property, a number of items were discovered. Among the items discovered was an air mattress containing the DNA of Sierah Joughin. In a green crate in that same area of the barn, investigators found a number of packaged items of lingerie, adult diapers, rope, duct tape, ball gags, sexual bondage items, and a pair of violet Vixen metallic panties. The violet Vixen metallic panties were bloodstained. DNA testing later revealed the bloodstains matched Sierah Joughin. The package items found in the green crate matched items in which Ms. Joughin was dressed when she was discovered in a grave. The duct tape found in the barn contained the DNA of both Ms. Joughin and the defendant. Ms. Joughin's family and her boyfriend testified that Sierah did not know the defendant. The defendant stated in his interview with investigators he did not know Ms. Joughin. Ms. Joughin's body was eventually found buried in a cornfield adjacent to County Road 7. Along the side of the road, investigators found a plastic glove containing the DNA of both the defendant and Ms. Joughin. When discovered, Ms. Joughin was wearing an adult diaper and other clothes similar to the items found in defendant's barn. She was hogtied with rope, similar to rope found in the defendant's barn, handcuffed with an old handcuff which utilized a unique key identical to handcuff keys found in the defendant's possession. She was also found with a dog chew toy inserted in her mouth, which had been modified to serve as a ball gag. The coroner ruled death was caused by placing this gag in the victim's mouth, cutting off the victim's air supply. The gag was placed with enough force to break Ms. Joughin's tooth. The court has presented these factual findings to provide background for the jury's verdict. The court has not considered the aggravated murder itself as an aggravating circumstances. The court recognizes that mitigating factors are factors, while they do not justify nor excuse the crime of aggravated murder, nevertheless, in fairness and mercy, are to be considered as they may call for a penalty of less than death. Mitigating factors are any factors about an individual or an offense which weigh in favor of the decision that a life sentence is the appropriate sentence. With respect to nature and circumstances, this court has weighed the nature and circumstances of the offense for any mitigating factors. The court can find no significant fact relating to the nature and circumstances of this offense which it would consider mitigating. The history, character, and background of James D. Worley. The defendant, for the most part, was raised in rural northwest Ohio. Defendant's father was in the military. After leaving the military, he attained some college education and began working in management at Johns Manville. Defendant's parents later divorced. His mother remarried a former drill sergeant. The defendant recalls being happy in his childhood. He indicated he had great respect for both his father and his stepfather. The defendant was one of 3 siblings in the household. His older sister eventually left home, moved to California, where she has served 27 years for the Los Angeles Police Department. She's currently a sergeant. Defendant's brother suffers from mental disorders, which required medication. His brother has always lived on the family homestead. The defendant's sister indicated in her statement that the defendant's father did have issues with alcohol and he would become abusive when he drank. She reported an incident where her father chased her mother around the house with a butcher knife. Defendant's sister never indicated the abuse was visited upon either herself or her siblings. Defendant's sister further indicated her stepfather had raped her on at least 2 occasions, and the defendant had walked in while these rapes were occurring. The defendant did not recall either of these events. Although possessing an average IQ, the defendant was not a good student. The defendant indicated he was more interested in having fun than he was in studying. His grade point average was certainly not spectacular. Otherwise, there is nothing remarkable about the defendant's educational background. The defendant worked at various jobs and attempted to start several businesses. He was, for the most part, unsuccessful in his efforts at self-employment. He eventually determined, as his mother was elderly, he needed to stop working outside the home and simply devote his time to caring for his mother. As a result, he started a small engine repair shop on the family homestead. It did not appear that this business was successful. Dr. Fabian found that the defendant had only good feelings about his upbringing, yet Dr. Fabian indicated the defendant did suffer trauma in early childhood. And though Dr. Fabian could not conclude specifically what trauma the defendant did experience, only that Dr. Fabian's diagnosis clearly indicated such a trauma must have occurred. The defendant, in his statement to Dr. Fabian, did state that he had only good feelings about his upbringing. Dr. Fabian admitted it was difficult to examine Mr. Worley because of his lack of candidness and not being forthcoming with relevant information concerning his instant offending behaviors. Without reference to some specific trauma in childhood, it is difficult to give much weight to the issue of history, character, and background of the defendant as mitigating factor. The court can find little in the defendant's history that gives rise to mitigating factors and therefore accords little weight to its analysis relating to the defendant's history, character, or background. Other mitigating factors which may favor a sentence of life without parole pursuant to Revised Code Section 2929.03b7. The court has taken into consideration that the defendant did provide quality care for his mother and demonstrated a genuine concern for her welfare. The defendant also appeared to have a genuine concern for his brother's welfare. The defendant's brother has a history of mental health issues. The court deems the defendant's care and concern for his family to be a mitigating factor and gives some weight to that mitigating factor. The defense has relied heavily upon the report of Dr. Fabian, its mitigation specialist. The court has reviewed the 61-page report of Dr. Fabian. The report sheds light on the relevant mental health and personality disorders from which the defendant suffers. The defendant further suffered from numerous mental illness disorders. According to Dr. Fabian, the defendant's expert, the defendant suffered from the following conditions: sexual sadism disorder, fetishistic disorder, paranoid personality disorder, persistent depressive disorder, cannabis use disorder, attention deficit hyperactivity disorder, combined type, inattention and impulsivity, possible mild neurocognitive disorder due to concussive history, dual diagnosis, antisocial personality disorder, narcissistic personality disorder, obsessive compulsive personality disorder, attachment disorder. The court has reviewed Dr. Fabian's report and his testimony relating to the defendant's various personality disorders and mental illness. There is no doubt that Dr. Fabian was well qualified to make his determinations as to the defendant's mental health. As to Dr. Fabian's findings regarding the possible mild neurocognitive disorder due to concussive history, there is nothing definitive in doctor's report indicating that the defendant had received a concussion during his childhood. Dr. Fabian discussed this issue in terms of possibility. The defendant did report being in an automobile accident. He indicated he did not have a blackout. There apparently was some trauma. Whether the defendant was concussed to the extent that damage occurred to his brain is speculative at best. The court therefore gives this portion of Dr. Fabian's report little weight in considering it as a mitigating factor. With respect to the cannabis use disorder, Dr. Fabian opines that Mr. Worley had used cannabis in larger amounts for a long period of time. He has spent a great deal of time and activities necessary to obtain cannabis or use cannabis, has a strong craving, desire, or urge to use cannabis, and the defendant has likely had difficulties in fulfilling major obligations for work due to cannabis use. Dr. Fabian also indicated the defendant had continued to use cannabis even though it had caused personal problems in his life. Dr. Fabian further indicated the defendant lacked insight into his cannabis addiction. The defendant was previously convicted for operating cannabis growing operation. It is clear that the defendant was, however, voluntarily participating in smoking cannabis. He, along with many others, frequently lack perspective as to the ultimate effects cannabis may have on the individuals. Regardless, the court gives little weight to this mitigating factor. Dr. Fabian indicated the defendant had a persistent depressive disorder, which is lower level and less severe than a major depressive order. The diagnosis indicates that the defendant may be irritable, angry, have a lack of energy, avoids social activities, loses interest in daily activities, and feels empty and sad. His clinical assessment of depression was in the mild clinical range. The court gives little weight to this mitigating factor. The court is convinced the defendant did suffer from the other diagnosed personality disorders and mental illnesses as described by Dr. Fabian. The court does not believe that the defendant's personality disorders and mental illness were so persuasive that the defendant lacked substantial capacity to appreciate the criminality of his conduct or to conform his conduct to the requirements of law. Were this true, the court would surmise the defendant's past criminal conduct would have been far more pervasive than demonstrated in the record in this case, notwithstanding the defendant's 2 prior felony convictions. Dr. Fabian could not determine the defendant's exact motivation for the current offense. On page 61 of his report, Dr. Fabian reports, whether killing the victim was part of his fantasies or a way to eliminate a witness, I am uncertain of. Such is the difficulty the court is experiencing in reviewing any and all of the personality disorders and mental illnesses from which the defendant suffers. The defendant made a more certain diagnosis less possible because of his lack of candidness and not being forthcoming with relevant information concerning the offense in this case. Dr. Fabian admits that it was necessary for Dr. Fabian to construct the roots of the offending behavior based on his assessment, past and present law enforcement records, review and research, and finally, his experience with this type of offender. Lastly, Dr. Fabian rightly indicates that I objectively am presenting potential mitigating evidence, and I say the word potential because the jury must make meaning of mitigation and aggravating factors as they see fit. Their contemplation decision as to what mitigating factors are relevant in sentencing may be different or the same as my investigation as to mitigating factors. That's taken from page 42 of Dr. Fabian's report. The court must also make its own determination as to whether the defendant's diagnosed mental illness and personality or disorders constitute mitigating factors. The court has concluded that the mental health infirmities suffered by the defendant do constitute mitigating factors and that they should be given some weight. The court does believe that the diagnosis of personality disorders and mental illness as described by Dr. Fabian should be given some weight due to the cumulative nature of these mitigating factors. Pursuant to Ohio Revised Code section 2929.03F, the trial court is required to make certain findings. A trial court must specifically provide reasons why the aggravating circumstances the offender was found guilty of committing were or were not sufficient to outweigh the mitigating factors. The court has cited case law to support that analysis. To satisfy the statutory and case law requirements, this court has undertaken the weighing process. Again, the court has not considered the aggravating murder of Sierah Joughin as an aggravating circumstance. The court further acknowledges that the defendant has no burden of proof. The court has considered all of the evidence presented during both the trial and sentencing phases as it relates to the aggravating circumstances involving the aggravated murder of Sierah Joughin. The court has also considered all of the mitigating evidence and mitigating factors presented at both phases of the proceeding. The court has weighed the aggravating circumstances against all of the mitigating factors and mitigating evidence. The court has weighed the mitigating factors both individually and collectively. Mitigating factors are factors about James D. Worley or the offense that James D. Worley committed that weigh in favor of the decision that a life sentence rather than a death sentence is appropriate. Mitigating factors that lessen the moral culpability of the defendant or diminish the appropriate, mitigating factors are factors that lessen the moral culpability of the defendant or diminish the appropriateness of the death sentence. The relevant mitigating factors can be considered by the court, have been previously outlined in this opinion. The court has fully considered and weighed all of the mitigating factors carefully and fully. The defendant purposely caused the death of Sierah Joughin for the purpose of escaping detection, apprehension, trial, or punishment for another offense committed by the defendant. In weighing the specific aggravating circumstance against the mitigating factors, the court finds that the state has proved beyond a reasonable doubt that the specific aggravating circumstance the defendant was found guilty of committing outweighs any and all of the mitigating factors. The mitigating factors pale in comparison to the specific aggravating circumstances found by the jury. When weighed against the mitigating factors, the aggravating circumstance in this case, beyond a reasonable doubt, far outweighs any and all mitigating factors. There is no doubt that James D. Worley has mental health issues, and these factors must be weighed, however, against the desire to save himself from prosecution for the offense of kidnapping. In essence, these issues must be weighed against the purposeful killing of Sierah Joughin. The overall value of the mitigating factors when compared against the specific aggravating circumstances is minimal at best. The court has weighed all of the mitigating factors when considered alone together or together. Those mitigating factors are not significant when compared to the aggravating circumstance in this case. Separately or together, those mitigating factors have little weight to lessen the moral culpability of the defendant. The court finds that the mitigating factors are simply insufficient when compared to the aggravating circumstance, and that the state has proven the aggravating circumstance outweighs any and all mitigating factors beyond a reasonable doubt. After weighing all the appropriate evidence, all mitigating factors, statement of counsel, and the statutory and case law required, it is the decision of this court that the specific aggravating circumstance in count 12 involving the aggravated murder of Sierah Joughin outweighs any and all mitigating factors beyond a reasonable doubt. The court therefore accepts the recommendation of the jury. The court orders that James D. Worley is hereby sentenced to death for the aggravated murder of Sierah Joughin. The court orders that the execution date of James D. Worley be set for June 3rd, 2019, to be carried out by the appropriate authorities. The execution date shall be subject to further order by a court of competent jurisdiction. Defendant James D. Worley shall be remanded to the appropriate Ohio prison institution to be held on death row pending his execution. The court herein orders that the Fulton County Clerk of Court shall forthwith deliver a copy of this entire case file to the Ohio Supreme Court pursuant to Ohio law. The court shall further appoint appellate counsel for the defendant. The court herein appoints capital certified appellate counsel as follows. Gary Krim of Dayton, Ohio, and Andrew Avellano of Columbus, Ohio. Both are on the capital case appellate counsel list. The court shall further provide a copy of this entry to the clerk of the Supreme Court of Ohio, along with the appropriate case disposition form required by the Supreme Court. Court costs shall be taxed to defendants James D. Worley according to law. It is so ordered. I have signed my name to this. Copies of this sentencing form shall be available from Ms. Bainfeld for those individuals who are interested. I'm assuming the press will want copies. We are now on for sentencing in the balance of the case. Are there any other items in mitigation that we should hear at this time? Mr. Deck?
Only in that I believe the honoree soliloquy on the record by my client earlier confirms quite strongly that most of the findings not affected.
Does the state have any evidence it wishes to provide at this time?
The State, Your Honor, would only point out that we would ask that all of the other counts be run, be given maximum sentences, and that they run consecutively to one another and with in connection with the death penalty. And with that, Your Honor, I also have impact statements that the family has asked me to read to the court.
These are all from victims, is that correct?
This is from members of Sierra's family and close friends, and then there will be, after I've completed Sierra's and Sierra's mother, will address the court first.
Thank you. Please proceed.
James Worley, you have taken from my family our first granddaughter, one we held in our arms the day she was born. A granddaughter we heard cry and laugh, a granddaughter we seen crawl, then walk, a granddaughter to grow up to be a strong and beautiful woman. That being said, you, James Worley, I tell you, as for my family, we will live and laugh and love again because my family is strong. Pete Schaefer. This is from Sierra's great aunt, Jill Brown. Your Honor, I will never forget the call I received from my sister-in-law, Sierra's grandma, on July 19, 2016. I know it was serious by the tone of her voice. When she told me Sierra was missing, it took my breath away. I thought this couldn't be because Sierra was so responsible. When I called later and she told me they still hadn't heard from her, I made the decision to fly from Oregon to her home to help look for her. When I arrived, it was chaos. People coming and going looking for C. It was then that I saw my brother, Sierra's grandpa, sobbing and unable to breathe. I have never seen him so broken. The next 2 days were unbearable. Then the news came that they found Sierra. I have never seen or felt such grief in all my years. In that moment, our lives changed forever. You need to understand what this repeat offender monster took from us. Sierra was so full of life, joy, and love. She worked hard for everything she had. She lived life to the fullest. Her smile lit up every room she entered. She had a heart of gold, always looking out for others. How could this happen to such a beautiful young lady that was loved by so many? I sat every day in your courtroom with my family as we listened to the horrific things this monster did to Sierra, and so did the jurors. I'm just asking that you would be respectful of the time, energy, and emotion that the selected jurors put into making their decision of guilty on all 19 counts and the recommendation of the death penalty. I am thankful that no matter what, James Worley will never be able to do this again. It doesn't make the ache in our hearts go away. Sierra's mother will never have her daughter back. Sierra's sister and brother will never have their sister back. Sierra's grandparents will never have their granddaughter back. Sierra's aunt and uncle will never have their niece back. Sierra's boyfriend Josh will never have the love of his life back. However, Sierra will continue to live every day in our memories because she was in a majority of them, and we will make new memories as a family because that's what she loved most. You can never take that away from us. Thank you for reading this. Jill Brown. This is from the defendant's grandmother, or excuse me, the victim's grandmother, Sierra's grandmother, Kathy Schaefer, Your Honor. A grandmother should never have to write one of these, but I find myself feeling that I have to do this for my beautiful Sierra, Cece. Where there is great loss, there was great love. Sierra brought so much joy and life to our family as she was the first grandchild, first daughter, and first niece. You might think she would be spoiled with all the attention she got from all of us, but she wasn't. As our family grew with more grandchildren, Sierra continued to be the motivator that got everyone moving to experience all that life had to offer. She was a mover and shaker, never wasting time for a minute. Family time was so important to her, whether it was holiday traditions, family vacations, going to the lake, or paint parties at home. She was always getting everyone involved. The week before her abduction, she was planning a family movie night. We were all going to see Secret Life of Pets, Wednesday, July 20th, 2016. We never got to do this because we were searching for Sierra. Her brother Hunter celebrated his 11th birthday on July 21st without the family as we were searching for his sister. Ava adored her big sister and looked up to her. Sierra followed their sports activities as much as she could and always was their biggest fan. Younger cousins also have fond memories of the time spent with Sierra. 6-year-old Emily will tell you Cece taught her how to ice skate. Shyla and Aaliyah remember the yearly making of gingerbread houses for Christmas. Sierra was always Santa's helper at the annual Santa parties. Who was going to help Santa this year? Lots of memories were made by the entire family at Coldwater Lake, decorating the golf cart for the 4th of July parades, tubing, jet skis, and bonfires. Every single one of us has great memories because that is what we did. That is what our family was all about, being together and enjoying each other. Then a monster came into our lives on July 19, 2016. Someone that we should have known had a violent past, but we didn't. Something as simple as a bike ride became our painful tragedy. My children, Sierra's mother, uncle, and aunt, had ridden their bikes numerous times down our road. Sierra and I used to rollerblade down our road. I was going to get a bike so we could ride together down our road. That never happened. Now I am afraid to walk down my own County Road 6 as I have done for decades before, because one evil monster's decision to please his own sick passion. And I say passion because he did this once before, but it was not successful. His victim was able to escape that time. He was definitely prepared for the next victim that came his way. How many more could there have been between then and July 19, 2016? So now, trial is almost over, and I don't feel any different. Family all knew he was guilty, and hearing the juror's guilty verdict confirms that others know the monster he is. That still doesn't change anything for us. We still don't have Sierra. She's not coming back to us because of this guilty verdict. We have to pick up our lives and continue on doing all the family activities that we do without her. Without her smile, without her fun and games, without her love and affection, without her voice, her sweet voice saying, "Nana, what are you doing today? Do you have time to?" We suffer this loss every time we get together. I agonize every single day over the hole that is left in my heart. The loss I feel is unbearable at times, but then there's the tragedy associated with how we lost her that makes me so angry. Imagine telling children 11 and 8 years old that their sister is never coming home. How do you tell cousins who aged from 4 to 7 at CC, who played with them and had fun with them and taught them fun things, that they will never see her again? What this has done to these children is heartbreaking, and no child of their age should ever have to experience what they've had to go through at such a young age. But it's not only the young ones. The three musketeers, as they called themselves, Sierra, Nick, her cousin, and Josh, her boyfriend, friends since they were 7 years old. They did everything together. They were devastated. This monster took Sierra's future from her. He plans to study in Spain, graduate college, pursue her career and travel, and then marry the love of her life, her best friend Josh. These were all ripped from her by someone who should have never been released from prison. We knew Sierra was destined for great things. We just never knew the depth of those great things. She took out a killer who lived among us, and we never knew it. She took out evil so that he cannot hurt another innocent life. She took out a monster that will never bring the hurt and sorrow that we have to live with for the rest of our lives. He will never bring that to another family again. Bless you, beautiful Sierra. She continues to work through the strength of her family. We will never let her be forgotten. It is my hope and prayers that this man will receive the highest punishment of death. I would only hope that he would give up other victims so that their families can have the knowledge of knowing where their loved ones are. It doesn't bring closure. It doesn't bring a sense of peace. We didn't win because of this verdict. We would still be searching if we didn't have the answer. Guilty. Thank you for listening. The next letter, Your Honor, is from Bob and Nikki Kolodzinski, Josh's mother and father. Judge Robinson, what does one say at a time like this? It's the same speechless quiet like when I had to try to explain to Josh why she was missing, when I had no answer. When I had to hold my young adult son in my arms and just tell him I loved him because there was nothing else to say. When I look into Josh's eyes and see the pain, where I actually feel his pain in my chest. Being speechless, when all you can hear are the screams of your son, when we were told she was dead. Dead a word that should never be in any sentence with the name of a child, a young woman named Sierah, then murdered, then tortured while we searched for just a little over a mile from where she was held captive. I returned to that night, and it makes me sick to my stomach knowing she was so close and none of us could help her. My mind needs to go to the good, the joy she brought everyone she came in contact with. Sierra C. was able to know something special about everyone, and at special moments would let you know that she loves you. Whether it was that little defiant no, or just a little longer hug. She came into our lives when she was about 7 years old, friends, then special friends, then dating, then going off to college. Then, Mom, we were looking at rings. I say, how do you know she's the one, honey? To which to have Josh answer, if you know you can't live without her, that makes her the one. Josh and Sierra's love was one of those love stories we all wish we had. They loved each other with a bond that any two people who have been together for 50 years would know about. Now we understand why she lived and loved with so much passion. Memories flood my mind. Josh and C sitting on the couch looking up faraway places to travel together to on the computer, dreaming of a day that they could go. Then skydiving, pictures of this time at some of my favorite. Flying free, hundreds of miles above the earth, taking the chance to experience life in all its glory. Sierra was to be Josh's wife. We have mourned and continue to mourn her loss. The loss of their grandchildren we will never have, the loss of our son. We lost part of him that night. We lost part of all of us that night. It makes me so sad. But God will bring Josh and us from the ashes. I truly believe this. Josh could not bring himself to write a letter to you. It was too painful to write about his beloved Sierra. He also couldn't write regarding any sentence for her murder. He asked that I mention to you a little something about him and C. So I think I did that, and I also enclosed some photos that speak louder than words. Just know that Josh and Sierra loved each other as hard and as life would allow. This will be internal, and Josh knows this in his heart. I would like to thank you for your ruling allowing Robin Gardner to testify. It not only helped her heal a little more after all these years, but she was Sierra's voice in that courtroom. She had a voice that wasn't silenced by a monster, but was heard by so many. Sierra had a voice. Josh has a tattoo on his arm that says, some dream of angels, but I held one. He truly held one, and C has become everyone's angel. The love and support of our community is nothing more than God saying, evil will not win. C was our daughter of the heart, and will be missed until we can be with her again. We know and trust your will, and in saying that the right thing is God's lead. We are grateful this monster will never be able to hurt another person ever again. Thank you for your time, and God bless you, Bob and Nikki Kolozinski.
You have those pictures?
I do, Your Honor. My approach.
Please. Any other statements? And
Yes, Your Honor. At this point, I believe Sierra's aunt, Kara Ice, would like to speak. And she's being accompanied by her husband, Your Honor, who is here to support her.
Your Honor, My name is Tara Ice, and I am Sierra's aunt. Sierra was a bright, shining light that will never burn out. To explain to you the impact that she had on my life is simply impossible. From the moment she was born, I couldn't get enough of her. I was 16 when she was born, and it could have gone two ways. First being that the house would never be quiet again, and studying would be hard. And second being I would never be able to sleep in again, which is important to any teenager. To my surprise, those were the two things I loved and cherished most about Sierra's youngest years. First thing in the morning, I could hear her tiny little voice saying, "Mom, I'm up, Mom. I want candy." I would giggle in bed at how much I loved this little girl that stole all of our hearts. As she got older, we would have sleepovers at my place, and we would eat kettle corn and giggle all night. She always had a way of expressing herself and telling these never-ending stories. I would give anything to hear another story or have another sleepover. I met my husband, and he brought two amazing boys into my life. Little did I know that Sierra and my oldest son, Nick, who was a month older than her, would become best friends. She traveled on most all of our family vacations, and I still just couldn't get enough time with her. She met her true love, Josh, at the tender age of 7 when Nick introduced his two best friends to each other. They soon became the three amigos and shared a bond that was so amazing. Because of a selfless, selfish act by a repeat offender, we will not hear her infectious laugh. We will not have those special family vacations. We will not see her walk down the aisle or have babies of her own. Her dreams of studying abroad and traveling the world will never come true because of this repeat offender. We had to celebrate Sierra's 21st birthday as a group without her here on Earth. The holidays are more quiet and somber and will never be the same. We light a candle to remember her spirit, but the light of that candle has nothing on Sierra. She would light up a room just by smiling. We have all this pain and loss because of a selfish person who thought he would get away with it. I quote the defendant on an audio recording saying, "The proof is in the pudding." He's absolutely right. I'm so thankful that the jurors were able to see through his lies and clearly see the proof in the pudding. I will never forgive James Worley for what he did. This heartless individual was sick enough to want to watch the life and the light drain out of Sierra. He thought he had the power to take her light from us, but he was mistaken. Her light can never be dimmed. Her light shines brighter today than it ever has before. Sierra has done more good and positively touched more people's lives in her short 20 years on Earth than most people do in their entire life. Not only did he take Sierra away from us, but he took away our family as we knew it. I have to watch the pain in my sister's eyes and the heartbreak of losing her firstborn child. I have to watch my niece not be able to have sleepovers because of her fear of being away from home. I have to watch the pain and despair in my parents as they struggle to understand how this could happen in the town they both grew up in and felt safe in. I have to try to explain to my young daughters why Sierra won't be coming home and that the boogeyman really does exist. I watch as my boys try to find their way in life while questioning everything because how could this happen to her? The pain is excruciating and the depth of emptiness we feel is unexplainable. However, I want him to know this. It may seem that he has broken us, but we as a family are stronger than he thinks. And because we were lucky enough to have had Sierra's love, were unbreakable. James Worley has long demanded that his human rights should be respected, all the while knowing that he had so callously dismissed Sierra's right to live. His jail records prove that he is a repeat offender and has no respect for authority. His demeanor in court proves that he has no remorse for what he did to Sierra, much less to all of those who loved and knew her. Our family has to spend the rest of our lives with the reality that Sierra will never be coming home, all because the heartless, cold-blooded decisions of James Worley. Let James spend the rest of his life paying for these decisions. Thank you.
I'm going to read our daughter Shyla, who's 9. What would you like the judge to know? How do you feel? What has happened to you? She said it's like kind of a big cake that I was going to make, and then C was the sugar. Then James took C out of the cake so that the cake tasted bad because it didn't have C sugar. And it devastated me. How are things going at school? Of all the people in my classroom say, like, what happened to your cousin, and I don't want to tell them. But my friends give me hugs when I'm sad. If you had to tell the judge about your feelings, what would you say? Death. So you can never hurt anybody again. My daughter Leah decided to write one as well. She's 7. She's in 1st grade. How do you feel? I feel sad, and I feel mad, and I feel confused. If you were to tell the judge, what would you do with James Worley? I'd send him to jail, death, so he can't hurt me. And then she drew a picture of hers.
Yes, Your Honor. Yeah, Sierra's mom, Sheila Factual.
Your Honor, I'm standing before you because my daughter Sierra was inhumanely denied the right to live out her life. Sierra was a compassionate, vibrant, and extremely driven young lady. She graduated from Evergreen High School with honors and was attending the University of Toledo, where she was on the dean's list, majoring in business. Sierra had a very social side. She was very active in several campus leadership organizations. Her freshman year, she became a member of the Phi Eta Sigma. They delivered packages for mobile meals, and they also volunteered at the Boys and Girls Club. That same year, she took a position of Star Status Coordinator for the National Society of Collegiate Scholars. This is an honors organization that recognizes and elevates high achievers. Their mission is that with scholarship comes the responsibility to provide leadership and service to the community. Sierra's sophomore year, she joined the Society of Human Resource Management and also was accepted into Alpha Kappa Psi Business Fraternity. She did all of this while keeping a 3.8 GPA and a full-time job with Wagner and Associates. These experiences and opportunities were very important to her, and she consumed as much as she could, but nothing was as important as her family. Sierra made it a point to know all of the younger kids' activities, school concerts, trips to the zoo, and definitely camping trips. A 20-year-old college student with a busy social life and a work life made it a priority to spend time with her younger brother and sister, cousins, aunts, and uncles. This was a soul that embraced living and everything that it had to offer. It is hard to put into words the feelings I have experienced over the last year and 9 months. The hole that will never heal in my heart.
Do you need a moment, ma'am?
And my family that I so cherish and am so very proud of will never be the same. I sat in this courtroom and I listened to the actions of a man who intimidated and dominated another human being. A man who acted out a sick and distorted scenario that he had played over and over in his mind. A man that showed no remorse for what happened to my daughter, to what my family was going through, or to what the jurors had to witness during this trial. As a mother, I should never have to explain to my 9 and 11-year-old what capital punishment is. I worry about the memories surrounding Sierra's death. My son was excited to be celebrating his birthday on July 21st, but now that is forever going to be a dark time for him. My youngest daughter was home and witnessed the utter chaos and emotional turmoil that was going on while we frantically tried to figure out what was happening. Their world was shattered, their innocence tainted by this heinous event that happened so close to home. For them, justice has been served, and the person that committed this crime is being held accountable. I, on the other hand, am not finding comfort in that he is just being held accountable. I continually ask why. Why her? Why didn't she get away? Why didn't we find her sooner? Why? For me, the death penalty is what he deserves, and not in 30 years. As if killing another person is not reason enough for capital punishment to be enforced. In 1981, Ohio added aggravated murder in addition to specific circumstances. James Worley not only kidnapped my daughter, he dehumanized her, killed her, and dug a hole so deep that my nephew could stand in it. James did not just try to cover up what he did, he deliberately attempted to bury her so she would not be found, like she was unwanted or disposable. But he was wrong, and in the process, he left behind a little piece of DNA, his DNA and her DNA, and that is not circumstantial. I agree with Dr. Fabian in that Worley has many illnesses, but I disagree with the defense in that they are reasons to spare Worley's life. James abducted a woman in 1990, and then he proceeded to own and operate several small businesses. Whether they failed or succeeded makes no difference. This is not a person who doesn't understand the effects of his actions on other people. He may deny his actions, but considering how hard he tried to hide Sierra's body, he knew what the ramifications would be. Sierra's life was worth far more than the 20 years she was able to live. She has inspired people she did not know, and I can only wonder what great things she would have accomplished if she was still alive. But in her death, I know she is moving mountains, and as her mother, I could not be more prouder of the person that she was.
Thank you. Any further statements?
No, Your Honor.
Would you ask the Kolazinskis, are these for the court's record? Or do you want these returned?
Those are for
They're
you,
for the
Your Honor.
court's record, thank you. If you could, I would like all copies of those statements brought. The court has considered the record, oral statements, the victim impact statements, the purposes and principles of sentencing as required by Revised Code Section 292911, the seriousness and recidivism factors relevant to the offense and offender pursuant to Revised Code 292912, and the need for deterrence, incapacitation, and rehabilitation. The court is guided by the overriding purposes of felony sentencing, including protection of the public from future crime by the offender and others, and punishment of the offender using the minimum sanctions the court determines necessary to accomplish those purposes without imposing an unnecessary burden on other state or local government resources. In this case, the court finds the defendant was found guilty of several charges, but those charges have merged into the following offenses: count 6, kidnapping, in violation of Ohio Revised Code section 2905.01b2, a felony of the first degree; count 7, felonious assault, in violation of Ohio Revised Code section 2903.11a2, a felony of the second degree; count 14, possession of criminal tools, in violation of section 2923.24a, a felony of the fifth degree; tampering with evidence in violation of Ohio Revised Code section 2921.12a1, a felony of the third degree; and count 19, having weapons while under disability, in violation of Ohio Revised Code section 2923.13a2, a felony of the third degree. The court finds the following factors making the offense more serious are relevant to the court's determination of Revised Code section 2929.12b. The victim of the offense suffered serious physical, psychological, or economic harm as a result of the offense. The court finds no factors making the offense less serious on section 2929.12c. The court finds the following factors indicate the defendant is more likely to commit future crimes, which are relevant to the court's determination under Revised Code section 2929.12d. The offender previously has a history of criminal convictions, and the offender clearly has not been rehabilitated to a satisfactory degree and has not responded favorably to sanctions imposed. The court finds the following factors relevant to future crimes. Unlikely he did not have a juvenile record. The court finds, after considering these factors, that a prison term is consistent with the purposes and principles of sentencing in Revised Code 2929.11, and the defendant is not amenable to any available community control sanction. The court further finds community control sanctions, or a combination of community control sanctions, would not adequately punish the defendant nor protect the public from future crime because of the applicable factors under 2929.12, and indicate a greater likelihood of recidivism, which greatly outweigh the applicable factors, indicating a lesser likelihood of recidivism. The court further finds that a combination of community control sanctions would demean the seriousness of the defendant's conduct and its impact on the victim, because one of the factors indicate the conduct was more serious than conduct normally constituting the offense, and that those factors outweigh any applicable factors indicating the conduct was less serious. The court finds that a sentence of imprisonment is commensurate with the seriousness of the defendant's conduct, and that a prison sentence does not place unnecessary burden on state or local government resources. The court therefore sentences the defendant as follows. On count 6, kidnapping in violation of Ohio Revised Code section 2905.01b2, a felony of the first degree, 11 years. On count 7, felonious assault in violation of Revised Code section 2903.11a2, a felony of the second degree, 8 years. In count 14, possession of criminal tools in violation of Ohio Revised Code section 2923.24a, a felony of the fifth degree, 11 months. On count 17, tampering with evidence in violation of Ohio Revised Code section 2921.12a1, a felony of the third degree, 36 months. On count 19, having weapons while under disability in violation of Ohio Revised Code section 2923.13a2, a felony of third degree, 36 months. These sentences are to be served at the Ohio Department of Rehabilitation and Corrections. The court has further decided the defendant shall serve the prison terms consecutively pursuant to the requirements of Ohio Revised Code section 2929.14c4, because the court finds a consecutive service is necessary to protect the public from future crime and to punish the offender, and that a consecutive sentence is not disproportionate to the seriousness of the offender's conduct and the danger he proposes to the public. The court further finds at least 2 of the multiple offenses were committed as part of one or more course of conduct, and that the harm caused by these offenses was so greater than usual that no single prison term for any of the offenses committed as part of this course of conduct adequately reflects the seriousness of the offender's conduct. And the offender's history of criminal conduct demonstrates consecutive sentences are necessary to protect the public from future crime by the other. As part of the sentence, although this will never occur, it's still required. As part of the sentence, the defendant is advised upon completion of a prison term, the defendant would be subject to such further mandatory period of supervision under post-release control of a mandatory 5 years as authorized by law. The parole authority may increase or reduce restrictions imposed by the parole board. In the event the defendant violates the terms of post-release control, the parole board may return the offender to prison for a maximum period of time for 9 months for each violation, but the total addition of prison time imposed by the parole board or under post-release control will not exceed 1/2 of the defendant's stated prison term. If the defendant is convicted of a felony while under post-release control, the court having jurisdiction over the new felony may return the defendant to prison under this case for additional period of time as authorized by law. And any prison term served will be served consecutively with any extension of time in this case. All of those sentences, whether from the parole board for post-release control, from the new court, are deemed to be part of the sentences in this case. Additionally, the defendant will pay the costs of prosecution in this matter. The court typically concludes this case by having a few comments. I have been told by my brethren who have handled these cases that is inappropriate here. Suffice it to say, Mr. Worley, I think you would have been well advised to listen to your attorneys before you made your statement. I thought your attorneys did an excellent job in handling your defense. And one further comment, Mr. Worley, if I thought there was a snowball's chance in hell that you were innocent, you'd be looking at life. Court's in recess.
All right.
Thank you, man.